Hi, my name is Antoni Casalinuovo, and I'm a lawyer at Ely Associates. Today I'm here to talk to you about the third and final E of the three E's of litigation, execution. Simply put, execution is how fast we can achieve the outcome. There are a number of factors that come into play, such as how quick you can gather the evidence, if there's been an extension of time to comply sought by a unit owner, or if a condominium corporation is commencing an action against a third party for damages. Section 23 of the Condominium Act requires that the condominium give notice to its unit owners. There are also a number of procedural steps that can result in delays. It can be from simply having difficulty trying to serve a party requiring time to get a lawyer, that lawyer requiring time to prepare responding materials because the party is going to dispute that the condo is entitled to the relief being sought. There could be other procedural delays, such as a party trying to exercise their right to conduct a cross-examination or discovery of a witness. The most common problem, though, is court availability. I always talk to my clients about the availability of courts. I remind them that they're usually one of thousands of parties who are seeking justice through the court system. Therefore, it sometimes can take months before we can appear before a judge to talk about their issue. Now, once all those procedural issues have been taken care of, you go to court and you get an order. There always could be issues with respect to enforcing it. The law is, once a judge has made an order, it takes effect on the date it was rendered. Now, the judge always has the ability to extend that. For example, they can give an order that says this order cannot be enforced for 30, 60, 90 days, you name it. This is because the judge felt that it would be fair or reasonable to permit the other party time to comply with the order. Depending on the relief being sought, it could take time simply say to change an alteration that's been done in the common elements or within a unit. In terms of enforcing a judgment, I always have a discussion with my clients with respect to reasonableness. This also deals with respect to cost. Now, the rule according to the rules of civil procedure is costs are payable within 30 days after they've been ordered. Again, the judge does have the authority to change this. Now, the most typical type of action that a condo is involved in the court process is an application under Section 134 of the Condominium Act. This is the section of the Act that allows a condominium corporation to commence an application to force a unit owner compliance with the community rules. Now, there's a provision under Section 134 that should the condominium corporation be successful and obtain an order forcing the unit owner to comply and is awarded costs, any additional costs that the condominium corporation incurred in trying to obtain this unit owner's compliance can be back charged to their unit. This then leads into another dialogue I have with my clients as to when this back charge should be paid. I caution clients who say 4 days is more than enough. I remind everybody that we usually get 3 to 4 weeks to pay a household bill. So if your actions are going to be challenged, are you going to be able to justify to a judge that the condominium corporation acted reasonably in rendering a quick turnaround for a back charge? I always preach that patience will ultimately put the condominium corporation in a strong strategic position should its actions come under fire. Now, in conclusion, the three E's of litigation all play into one another. It's important that the client and its lawyer have a dialogue about what their expectations are, what the evidence is, and how it's going to unfold. By creating that roadmap, the road will be less bumpy, there'll be fewer surprises, and it'll be a more efficient process for everyone. Thank you. For more information about this topic and others, please see the reading room at Condocentric.ca.